think we're starting to level out. Okay. All right. Welcome everyone to March 2022 Safety Council meeting. We are still plugging away through these Zoom meetings. So again, as I've repeated a million times, this is a Zoom webinar setting, so you will only see just a handful of us on your screen. There will be there is a chat box and a question box, Q&A box that's in the bottom of your screen. So at any point during this presentation, if you have questions, please don't hesitate to ask. So with that said, we're going to get Par started here with our prayer. Then we'll move over to pledge and with some announcements, and we'll get Amy going here. Par?
All right. Good morning, everyone. Can we bow? Father God, we just love you, Lord, today. We love you every day. And we ask right now, Lord, you just continue to cover everyone under the sound of my voice. Bless every company, agency, and all of those that are practicing the safety qualities, Lord, of their business. We lift the speaker up to you on today, Lord. We thank you for the Safety Council and all that they do for all of the agencies here in Springfield and abroad. Continue to give you all the glory and the honor. It's in your name I pray. Amen.
Amen. Thanks, Par. We'll get what screen? What am I doing? Share. All right. All right, let's get started.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Well, hopefully everyone is enjoying this roller coaster of weather. I hope maybe Par's knows somebody up top that can talk to Mother Nature. So weather has been kind of weird for us. Just a quick update with us on the Safety Council or Steering Committee. We are kind of working behind the scenes trying to prep our in-person. Hopefully we can go back to in-person, as you probably may not hear from our BWC reps, Jim and Brad. We don't have any updates on if or when we can go in person, but we are working behind the scenes to try to figure out how we can get everyone in person, get that breakfast going. I know I sure do miss it. I've got a Pop-Tart in front of me, so I miss the eggs and bacon and all that other good stuff. So just letting you guys know, we're working behind the scenes trying to figure out how to get us live. When will this happen? I don't know, but hopefully we can get us in person in the near future. So it looks like COVID is sort of slowing down now. So hopefully this is in our rearview mirror and we can kind of move forward with all of this. So that's kind of the update on our desk through the steering committee. So Jim, any updates with the BWC?
All right, thank you, Justin. Thank you, Par. Some quick things I want to talk about. But first, I'm going to give you a little scenario because OSHA came out with a new letter of interpretation for a record keeping situation. And the scenario, I'm going to give you a scenario. If you guys want to jump in the chat and tell me whether or not this is recordable, when I'm done with my talking points, we'll cover it. But essentially, the scenario is this: an employee finishes their shift, they go home, they get a call from work, and there's an emergency. They have to go back in. So they get in their vehicle, their car, and they start driving to work, and they're in a car accident. Pretty severe car accident. They're injured. They have to go to the hospital. They're hospitalized. So the question is that an OSHA recordable? Does that go on your 300 log? So again, if you're so inclined, please go into the chat, say yes or no. We'll see how you do. All right, as far as talking points, I got to mention Ohio Safety Congress and Expo. It's this week. It's Wednesday and Thursday. You can still register. I threw the link in the chat. There's lots of sessions. Again, you earn credits, activity credits towards some of our rebate programs, and then there's some that you qualify for continuing education credits as well. So please check that out. You get to pick your sessions, and also there's the expo. You'll be able to chat live with the vendors who are in part of the expo. So that's Ohio Safety.
Oh, he froze up on us. Or at least he froze up on my end.
Am I back?
Oh, you're back.
I'm sorry, we got new laptops and I'm having big time problems with my connectivity because of the laptop. Our IT folks can't figure it out, but I'll go ahead and finish up here. Check out our live events on our website for information on upcoming virtual trainings. I think Nancy sends that to you as well. Please share that with your colleagues. We have webinars and virtual training still going on, no classroom. That's going to continue. So please check that out. We have some that Brad's teaching on March 24th on Ergo Office. I'm teaching one on March 22nd on developing a driver safety program. And then there's a whole bunch. But again, go to our webpage, just scroll down to events and you'll see all those as well. So back to our scenario. The answer is yes, it is a recordable. So during your normal commute to work, it would not be a recordable, but since you were called in, it's a special situation. OSHA says this is work related. So it is a recordable. So the next question would be, is it reportable? And since they were hospitalized, the answer is no, because it happened on a public roadway. Normally, if you're hospitalized, it would be a reportable. But since this accident occurred on a public roadway, it's not reportable. It's kind of a weird situation. If you ever have questions regarding that, obviously feel free to reach out to myself, reach out to Brad. We're here to help you. And again, we are back out in the field. So if you have any need for assistance with your safety programs, please let us know. I'll put my contact information in the chat. Sorry for zoning out on you there for a minute. Thanks, guys.
Thanks, Jim. If you guys are not only already confused with record keeping, now you are more confused. So record keeping is very confusing. So if you have questions, like Jim said, reach out to him. You can reach out to any one of us. Most of us have an understanding of record keeping, so we can assist in any manner. And on that topic, real quick, electronic record keeping was due already. So if you are required to submit your records, OSHA forms online, you should have done that already. If not, you might want to go ahead and do that now. And you should have posted them in your workplace already last month. So with that said, I want to introduce Amy, our speaker for today. Well, where did her? Oh, there it goes. There it is. So Amy is a director with Almond, Mahan and Fury. Amy Mitchell concentrates her law practice in the area of labor and employment and is certified as a specialist in labor and employment law by the Ohio State Bar Association. Amy advises business clients in matters relating to termination, discrimination, harassment, and the Americans with Disabilities Act, the Family and Medical Leave Act, competition agreements, wage and hour, and a host of other rapidly developing employment laws. In addition to advising clients on a day-to-day basis, Amy represents employers in administrative actions before the Ohio Civil Rights Commission, Equal Employment Opportunity Commission, the Department of Labor, and state and federal courts. Amy is a member of the Ohio State Bar Association, the Dayton Bar Association, the Society of Human Resource Management, and the Miami Valley Human Resource Association. She received her undergrad degree from the University of Dayton and her law degree from the University of Cincinnati College of Law. Fantastic resume. So please welcome Amy Mitchell. The floor is yours, Amy. Well, real quick, if during your presentation, if there's questions, I'll monitor that chat box. And do you want me to interrupt you as it goes on, or do you want to save it till the end?
Please go ahead and interrupt me. That'll be fine. I want to
Okay.
make sure we talk about the subjects you guys want to talk about today. Do you want me to share my screen and go through the PowerPoint?
Yes,
I
if that
will.
would be great. Yep.
I will do that right now. I will try to do that right now. All right, can you see that?
We can.
Okay, great. All right, thank you for having me this morning. As I said, I think a few minutes ago, we had, obviously this topic was selected back when COVID was the only thing that we talked about. From a labor and employment standpoint, COVID has, I would say, been 75% of what I've done for the last 2 years. But as COVID evolved and the laws evolved, we're kind of getting back to application of our normal labor and employment laws to the COVID aftermath is kind of what I'll talk about it. And one of the COVID aftermaths we're dealing with is COVID vaccines, how to handle that, and specifically how to handle COVID under the Americans with Disabilities Act, which is a large part of the COVID vaccine analysis from a labor and employment standpoint. So I'm going to give an update on kind of where we are. If I can get my screen here too. There we go. On where we are on the federal COVID mandates. We had a lot more to talk about a couple months ago than we do now. But I'm going to talk about the federal COVID mandates and then the employer's right to mandate it. And if you do mandate the vaccine because you choose to voluntarily or based on customer requirements, kind of what the process is that you have to follow in order to do the mandate and what the risks may be from a labor and employment standpoint. So as I'm sure most of you know, all of you know, OSHA originally released its vaccine or test mandate for private employers. The Supreme Court, everybody went through preparing how to implement that. And then the Supreme Court stayed enforcement of that. And OSHA then withdrew the ETS with requiring the vaccine or test. However, OSHA did state that although they withdrew the ETS, they are not withdrawing the ETS as a proposed rule. In other words, they may opt to reissue that as a proposed rule. Another sector of the workforce that was dealing with vaccine mandates prior to OSHA and really all the way through is the federal contractors, and the executive orders were issued back in September that required certain federal contracts to include a clause implementing COVID-19 vaccine mandates. That was an interesting rollout because federal agencies were issuing the clauses. They didn't really know who it applied to. They were just rolling it out and putting it in contracts. It was becoming a huge issue for contractors because many contractors have a very low level of vaccinated employees. Several federal courts looked at it. We had all these different federal courts issuing stays. Georgia, a federal court in Georgia finally issued a nationwide stay in December. That stay was upheld by the 11th Circuit Court of Appeals as a nationwide stay. So the general federal contractor vaccine mandate has also been stayed. The CMS mandate for healthcare workers, several states filed suits and injunctions were issued, but right now the way it stands, and again, it's a complicated analysis based on what state you are in and the circuit court decision, but the mandate currently appears to apply in 25 states. So healthcare workers are still currently under the vaccine mandate. So that's kind of the federal mandates that were requiring employers to mandate the COVID-19 vaccine. But outside of being required to mandate the vaccine, private employers, federal law does allow private employers to mandate the COVID-19 vaccine for its employees as a condition of employment, unless an employee on an individual basis is entitled to an accommodation what's been commonly referred to as an exemption for religious or disability reasons. So OSHA kind of stepped in when you guys were kind of mentioning record keeping, and I thought I would mention that this is still the stance from OSHA as a result. The question was, what happens? What does federal law say? What does OSHA say if I mandate the vaccine and my employee has an adverse reaction to the vaccine? And they said, essentially, originally it looked like, well, if there's an event there, there's going to be a record keeping requirement as a result of that. But OSHA said, we do not wish to have the appearance of discouraging anyone from receiving the vaccine, and we don't want to have anything in place that would disincentivize employers to have their employees vaccinated. So OSHA elected not to enforce the recording requirements if workers have an adverse event or side effects from a COVID-19 vaccine, at least through May of 2022. That's where it stands. However, it is important to note that an adverse reaction to the vaccine could be compensable as a workers' compensation claim if the employer mandated it. But the employee does have a high burden, and we have started to see some of these being filed and have successfully defended at this point workers' comp claims as a result of an adverse reaction to the COVID-19 vaccine, because the employee is required to get a diagnosis indicating the medical condition that resulted from the COVID-19 vaccine, and to establish a causal relationship between the vaccine and the diagnosis. And that is very difficult to get a doctor to do. State laws have jumped in where federal law says, yes, you can mandate this vaccine. Private employers can mandate the vaccine. States have jumped in and adopted some restrictions on whether you can mandate vaccines as a private employer. While other states have gone the opposite and then actually mandated vaccines for state workers. So, I mean, as you know, as everybody knows, throughout the last 2 years, what state you're in, I think, has mattered more than at any other time in employment law that I've been practicing, and I probably at any other time in our history. The state that you're in really controls kind of the COVID experience you had. I think Ohio, we were probably somewhere in the middle from some states that were much more restrictive and or mandating vaccines, from other states that actually have adopted laws that prohibit you from mandating vaccines. So Kentucky and Ohio, the states around here, there's no laws addressing whether you can mandate or not mandate a vaccine, a COVID-19 vaccine. So if you do decide to mandate a COVID-19 vaccine, either because your customers are requiring it or because you just choose to on your own, federal law does require you to offer and consider requests for exemptions to the COVID-19 vaccine. Specifically, we're generally looking at Title VII and the Americans with Disabilities Act. And this is really important that these requests for what is commonly referred to kind of in the media as exemptions, they're really accommodations. It's a request for an accommodation to be exempt from the COVID vaccine mandate that the employer has implemented. And you're not required to grant them, you're required to consider them, the requests. So I think that's an important distinction. So how does Title VII and the Americans with Disabilities Act apply? Well, Title VII applies because it protects an employee's right to express its sincerely held religious beliefs and to not be discriminated against based on, not be discriminated against based on his or her sincerely held religious beliefs. It's important to note that religion under Title VII includes not only traditionally organized religions, like you would think of, your Catholic, your Lutheran, but also religions that the employees express that are not recognized religions. They don't have to have a name, a title. The employee can just express, these are my sincerely held religious beliefs. I don't have a name for my religion. I don't go to church. I don't have a pastor or priest that can sign off on this. I've just decided this is how I practice religion. So it's been an interesting development. I would say in the past, I've been practicing law for over 20 years, and I rarely dealt with religious discrimination or religious accommodation claims. I would say probably 5 times throughout my practice. But over the past year with the COVID vaccine exemption, I have reviewed hundreds and hundreds of religious discrimination, religious accommodation requests based on the COVID-19 vaccine. And it's not black and white. It's a very gray analysis. It comes with a lot of skepticism from the employers often. Like, I didn't know this person was religious. This is the first time they've mentioned religion in any way. But that doesn't necessarily invalidate the fact that they are expressing a sincerely held religious belief. So it's important to understand. So when you look at these sincerely held religious beliefs, if it doesn't have to be a religion, well, what is it? It's the person's, and this is how well kind of the Supreme Court and the EEOC, who enforces Title VII, explains things for attorneys to then interpret and apply in real world. It's the person's own scheme of things. It's the belief that occupies a place in the life of the person that would otherwise be filled by God if you were in a traditional religion. That's not very helpful. It's kind of like the definition for pornography. Like, I'll know it when I see it kind of thing. It's kind of what the religious analysis is. I'll know it when I see it. The one way that they really look at the vaccine issue, because this is not an entirely new issue, employers in the past have, mandated flu vaccines or other vaccines. So this analysis has been done pre-COVID, and it was a matter of us taking the pre-COVID law and apply it to COVID. And that did not also always fit very nicely because courts, frankly, wanted a different analysis than necessarily the pre-COVID law would give you when applied to the COVID situation. So it wasn't a neat process to take the pre-COVID law and apply it to COVID, but that's what everybody was doing, hoping that the courts would be consistent in that. They have been consistent in some respects, but not consistent in others. And if you've seen some of the court cases on requests for exemptions from mandated COVID-19 vaccines, not a lot are prevailing. There are some courts that have sided with the employee to uphold their religious accommodation request or medical accommodation requests, but there's a lot of courts around the country that didn't necessarily follow the pre-COVID law in applying this. One thing that is important to note if you're reviewing any of these religious accommodation requests is social, political, or economic philosophies, as well as personal preferences, are not religious beliefs protected by Title VII. So for anybody that requested a religious accommodation to be exempt from a COVID-19 vaccine mandate and referenced politics, referenced whether they thought the vaccine was a medically good decision for them, whether they thought the vaccine worked, all of those things, those are not religious beliefs that are protected from Title VII and would not entitle the person to an exemption under the law from a vaccine mandate. While at the same time, they say it has to be religious, employers need to review this to determine whether they should grant an exemption. They then say sincerity should not be questioned. That's where it's become very difficult. Anybody can write a really nice statement on religious beliefs. And a lot of the religious exemptions for the COVID-19 vaccine mandate were based on the processing of the vaccines with aborted fetal cells. And the Catholic Church kind of came out and said, no, that's not really good enough. And then priest with, I can't remember off the top of my head, one of the military institutions said, no, that is actually a good, valid religious exemption request. So we had even the organized religions couldn't agree on whether that was a valid exemption throughout COVID. So it makes it very difficult for employers to do it. But some employers were requesting pastors, priests to sign off on this. That is really not required. Pre-COVID was never required and shouldn't be required during COVID. So the accommodation analysis, if you mandate this vaccine, is you receive a request. I don't want to get the vaccine due to religious reasons. And you say, okay, well, is this a religious reason? That's the first step. And we just talked about that analysis. But then even if it's a religious reason, the employers have a second step. And the second step is, okay, you have a religious reason protected by Title VII that you don't want to get the vaccine mandate, but can we actually accommodate that? Or does it impose too much of a burden on the employer? In other words, what it comes down to generally is, do I have work for this employee if they don't get the vaccine? If you have customer mandates, you may not have anything for this employee to do. So you may want to grant the exemption for the employee, but then you don't have any hours for this employee to work because you can't have them on site at certain customer locations. Now, if it's an internal, not customer mandated vaccine, there are things that the EEOC has suggested you can do to accommodate an employee who does not want to get vaccinated and has a legitimate exemption request. Testing, masking, social distancing, things like that are options. But it is very dependent on the facts of the situation, the workplace, the type of workplace you have, the type of work you have. So it's a very individual analysis. And that analysis should be done individually for each and every employee that requests an exemption. The EEOC has provided a sample form that they use internally. That took a long time to come through. We were in the midst of attempting to draft sample forms for employers to use. Most of them were very similar to this, but just for your information, here's what the EEOC requests when they're doing their analysis. So it's a pretty good sample to follow. When the federal contractor analysis came out, the SAFER, I always say this incorrectly, the SAFER Federal Workforce Task Force, I believe I said that correctly that time, also eventually provided a sample form, but these are the questions that you would want to be looking at for a religious exemption form. Obviously, you're identifying the requirement. Well, the requirement in this particular case is the COVID-19 vaccine. I have also seen religious exemption requests when the requirement that the employee is asking for an exemption from is masking and or testing. Those are much more difficult for an employee to get an exemption, but I have seen those as well. And you would go through the same analysis, regardless of whether it's the vaccine, whether it's the testing, whether it's the masking, or any other requirement. This analysis applies outside of COVID. So when we get to the point of talking about things other than COVID, this analysis applies to. It applies to shift work. It applies to, Saturday work, other types of policies and practices an employer may have that the employee says conflicts with their religion and they cannot complete. So this analysis applies outside of COVID as well. So they identify the specific requirement, then you ask the employee to describe the nature of the sincerely held religious belief that conflicts with the requirement, ask them what the accommodation they are requesting. Are they asking for completely to be exempt from the vaccine, or are they saying, and they get to number 4, are they saying, I want to be exempt from the vaccine, but I understand that testing may be required and, I'm willing to do the alternate accommodations for testing. Okay, Sorry about that. I'm home and thought my son was going to walk in. Okay, so that's the religious exemption. The Americans with Disability Act, actually didn't see as many requests for a medical accommodation exemption under the Americans with Disability Act as we did see under Title VII with the religious analysis, because it was frankly almost impossible to get a doctor to sign off that you could not get the COVID-19 vaccine. Now, I have seen them. There are some medical conditions that that employees have that made the COVID-19 vaccine a higher risk for them, or there are allergies that they had, other things like that. There were some, it just wasn't as many as the religious exemption requests that we reviewed over the past several months. So if they're requesting a medical exemption, that they're only entitled to a medical exemption if they have a disability under the Americans with Disabilities Act or a similar state law, which analyzes it the same. So I thought it was important to start with what is a disability, because that word is thrown around a lot these days. But a disability under the Americans with Disabilities Act is a physical or mental impairment that limits a major life activity. A major life activity can be something you see, like they can't walk, they can't talk, they can't see, they can't hear, or it's a major bodily function. So disabilities can be asthma, because that limits the ability of their lungs to function. It can be diabetes. So, in interior things that you can't see on the outside, or you can have a record of a disability and be protected. Or you can be regarded as an individual with a disability. So that's kind of the general ADA analysis of, is this person qualified as a disability, as having a disability under the Americans with Disabilities Act? One question that's coming up, I thought I would touch on this because I think I knew this issue was coming because of the natural immunity analysis. The EEOC kind of finally came out and said, yeah, we actually need to address whether a person that had COVID-19, if that constitutes as a disability or not. Will that support their request for a medical exemption? Because I'm sure most of you know, the federal government said that natural immunity was not a substitute for the vaccine when it was coming to federal contractor analysis and things like that. So the question is, well, what if somebody had previous COVID-19, which I think most people we know have had it at some point over the last 2 years, are they now protected as under the Americans with Disabilities Act as having either a current disability or having a record as disability, or are we now regarding that person as disabled and therefore cannot discriminate against that person? And of course, the answer, like all answers from the EEOC, is, well, sometimes it's a disability and sometimes it's not. It really depends on how serious the COVID-19 was for that particular individual. Obviously, an individual who had COVID-19 that had trouble breathing, that had long-lasting effects for several months, that person could qualify as having a disability because they are substantially limited for a significant period of time in major life activities, such as maybe they can't walk as far now, or they can't do normal daily life activities because their respiratory functions are limited. There are other long-lasting effects that some individuals have had from COVID-19 that could cause other side effects that could last for a long period of time. However, a person who had COVID-19 and they were sick for a couple of weeks, and then they resolved and they had no long-lasting effects, or maybe they didn't have any symptoms at all, they just tested positive, those people obviously would not be protected as having a disability. So prior COVID doesn't always check the box as, yes, you're now protected under COVID-19, under the Americans with Disabilities Act. So what is the accommodation analysis under the ADA when somebody says I can't get the vaccine because of my medical condition, whether that medical condition is an underlying medical condition, cancer, asthma, diabetes, MS, or COVID or prior COVID-19. Well, the question is, is the medical condition a disability? We just talked about that analysis. I did want to note here that the federal government issued its guidance saying pregnancy alone is not generally sufficient to get exempt from the COVID-19. That was from the federal contractor guidance. However, the EEOC does say if someone is pregnant and gets a doctor's note indicating they do not want to receive the COVID-19 vaccine, or if the employer just wants to say, yeah, you're pregnant, I obviously see your medical condition, I don't even need a doctor's note to see that you have that condition, and you do not want to get the COVID-19 vaccine because of that, is there a way you can accommodate that person? And although a pregnancy is not a long-term, limitation on somebody's medical condition, pregnancy, anybody that is pregnant is entitled to kind of the same analysis that you do under the Americans with Disabilities Act. Can you accommodate that medical condition? So it's kind of the one medical condition that, even though shorter in term and duration, is, the Pregnancy Discrimination Act protects those people the same, protects pregnant women the same as the Americans with Disabilities Act protects individuals with medical conditions. Most employers have required doctor signatures in order to verify that this employee does have a medical condition. Again, you are not required to do that. You can elect to accept, obvious disabilities. You may not need a doctor's note to certify that the employee has a disability. Prior COVID is, as I said, generally not sufficient unless it rises to the level of disability. And then normally there's just a short period of time the person would be medically exempt from getting the vaccine. I believe right now they have it at about a 90-day period, like you should not get the vaccine within 90 days of having COVID. I think they want to make sure you're fully recovered before you get the vaccine. So once you go through that analysis, you determine, yes, this person has a medical condition that qualifies as a disability. They have a doctor's signature, or you accept their medical explanation of they are requesting an exemption, a valid exemption from the mandate due to their medical condition. Then what do you do? Well, again, just because they have a medical condition does not mean you have to grant the exemption. They may have a valid medical reason for not getting the vaccine. And I saw many requests which were valid medical reasons for not getting the vaccine. But then the question is, are you required to exempt that person? Are you required to accommodate that person? You are not required to grant that accommodation exemption request if it causes an undue hardship on the employer. So how do you determine that? Well, is testing an option? Are there other options that don't impact, that don't cause an undue hardship on the employer that you can provide this employee instead of getting the vaccine? Do you have job duties for this person? Like I said before, if this is a customer mandate, the question then becomes, am I going to have work for this person if my customer is requiring all of my employees to be vaccinated? Will the customer accept my exemption? In some situations, when we're dealing with contractors, the customer has said, you do to the employer, you do the exemption analysis. If they're exempt, we'll implement testing requirements and masking requirements, but we don't want to see their exemption analysis. And they're doing that because they don't want to be on the hook, really, for granting or denying an exemption. Denying an exemption request, whether it's under the ADA or Title VII, obviously creates a legal risk. That person may end up, if you can't accommodate them, that person may end up having to change job duties. If you have other job duties the person can do, that person may end up being terminated. And as you've seen, I'm sure, and through the media, there are a lot of cases being filed for employees that were terminated as a result of their exemption request being denied. Those lawsuits are coming under many different laws, but primarily either Title VII or the ADA, depending on what their exemption request was for. Okay, so putting aside a mandate, many employers that we work with decided not to mandate the vaccine, but they decided to give incentives to their employees to get vaccinated. And many employers were surprised to find that actually the ADA and GINA, which is the Genetic Information Non-Discrimination Act, actually have something to say about giving incentives to employees to get them to either disclose their medical information or do some sort of medical test or medical procedure, which is what we thought the vaccine was going to be considered. But the EEOC has generally said that asking an employee if they're vaccinated or not is not asking them to disclose medical information that would be prohibited by the ADA, but also said if you do get that information, it's protected as medical information under the ADA. So make sense of that. Again, that's where some of our pre-COVID law wasn't necessarily interpreted in the same way when it was applied to COVID. So the ADA generally, I don't know if you guys have health incentive plans. There are limits on what you can give an employee to give an incentive. So those limits only apply if the employer or its agent is actually the one giving the vaccine. So in other words, if you have somebody come on site or you have a nurse on site handing out the vaccine, there are limits to the incentives you can give to an employee. However, if you just say, here's an incentive, go get the vaccine wherever and whenever you want, the EEOC has come out and confirmed that the limits on incentives do not apply to that scenario. So you can give whatever incentives you choose. I still think that there is some risk if you give a significant incentives. If you're giving out, $5,000, $10,000 to an employee who makes $500 a week, that may be looked at as coercive. And if it is looked at as coercive, the risks of workers' compensation could come in. I think you're going to win that one. But again, it could bring some claims if your incentives are so excessive that they look to be coercive. Okay, well, I wrapped that up pretty quickly because I wanted to leave time for questions and also because a lot of the issues have resolved with the Supreme Court decisions. So does anybody have any questions?
I haven't seen anything come up yet. However, I do have a question. Do you see, again, you're not a future teller, but do you see this eventually getting to like a flu shot type status in the workplace, or even the Hep B like type situation? Right now, it's a hot topic. Everybody's talking about it, but do you think it eventually just gets to, here's the new, we have a bloodborne pathogen policy. We offer the Hep B vaccination if you want it. If you don't, then no big deal, whatever. Do you think we'll get to that point that it's just kind of a way of business?
I think that we will get to that point. You're starting to see some states and cities that mandated the vaccine, roll those back. I don't think the federal government will roll back its guidance, indicating, or its Health and Human Services guidance that it should be mandated. I think they're going to be very cautious to roll back any requirements that they have now. But I think that we will get to the point that it's not going to be as significant as an issue, and it's just going to be another one of those optional vaccines. Depending on what they do with, mandating it for younger children to go into school, you may just end up at a point where all of your employees have it. So it becomes not an issue because your employees have it. But most of the mandates have been frankly rolled back. So I think we're kind of already at a point where it's becoming more and more just normal. And as they follow the CDC guidance, which is what OSHA is doing, generally following the CDC guidance, and the CDC starts softening, I think we're getting very close to a point where it just becomes like a flu shot.
Okay. While you were explaining, we had a couple questions come in. So question one, what are the potential issues if an employer asks for vaccination status and an employee does not declare and the employer assumes that they are not vaccinated?
I guess that's only really applicable. Maybe you can explain a little bit more, but it's only really applicable if the employer has requirements for unvaccinated employees. So for example, if you have testing requirements for unvaccinated employees or masking requirements for unvaccinated employees, and the employee chooses not to disclose, you can then, and not to confirm that they're vaccinated, you can treat them as unvaccinated and make them go through the other protocols. There's really no issues with that if you're giving the employee the option to disclose. And I do recommend giving the option to disclose or not to disclose if you have not mandated the vaccine. As I said, the ADA has said asking for vaccine information is not a prohibited medical question. So you can ask any and all of your employees. Your only requirement is once you receive that information, you need to keep that confidential as you would any other medical record. I think that dichotomy is interesting. It's not a medical question really, but it is a medical record. So your only obligation is to keep it confidential. And one way that we see that being brought up is you'll see emails, oh, so-and-so is out with COVID. They weren't vaccinated, so their quarantine period is X. And you're like, you just disclosed their confidential information. And so it's important that supervisors aren't discussing the vaccine status of employees. That really information should stay with HR.
Another one here is if you require testing as an accommodation, who pays for it?
If you're requiring the testing, so you've mandated the vaccine and now you're requiring the testing, without the OSHA mandate or any other federal mandate on top of it, it's probably going to end up being an employer obligation to pay for that testing.
Okay. All right. I don't want to put you on a spot. There was a question about, is this presentation available to distribute to the members? I don't want to put you on the spot, but that was the question that was asked.
Yeah, absolutely. You can distribute this to members. As with any presentation that we do, these issues are very factual. So don't take anything that I've said here as specific legal advice to your specific situation, especially in labor and employment law. Everything we do is very factual to the individual situation. So recommend you check with your legal counsel before following any specific legal advice.
Okay, great. I have not seen any more questions come through. As always, if there are questions, I guess is to the rest of the members. If there are questions, reach out to Nancy or myself. We can get in touch with Amy. I'm sure
my email is on the front of the presentation as well too. Feel free to shoot me an email.
Okay, great. Amy, I greatly appreciate your time. This is always a very fluid situation. So when we first talked or when we were trying to get you on, it was really crazy. And now it seems to kind of calm down a little bit. So I guess we wait a little bit longer and maybe it changes again. It's like the Ohio weather that we have.
That's right. That's right. Let's hope we're going to hit spring and no more COVID.
Yes, let's hope. So Amy, thank you very much for your time. I greatly appreciate it. It was good message, good information. So I do greatly appreciate your time.
Great. Thank you.
Yep. I did, for the rest of the members, I did skip over a BWC rep and I apologize. So Jim is going to introduce Tim McDermott. He's got a few words to say. So if you guys would all hang on for a few minutes. They have some words to say. Jim.
Yeah, thanks, Justin. Thank you, Amy. That was great. Really good information. Yeah, so Tim McDermott's a business consultant with the Bureau of Workers' Comp. He works directly with employers on our programs. You may or may not know him, but Tim's going to talk about the Substance Use Recovery and Workplace Safety Program. And I'm just going to turn it over to Tim. Thank you.
All right, thank you very much. I'm just going to take a few minutes to share some information on a new program that we have. It's called the Substance Use Recovery Workplace Safety Program. And the reason I'm speaking to you today is it's pretty timely, and there's kind of a deadline coming up where you could really take advantage of it. The program is part of the governor's initiative, Recovery Ohio, and you don't have to be participating in a BWC drug-free program. You can have a drug-free program of your own. Strongly encourage you to participate in ours, but you don't have to be part of our program to take advantage of this reimbursement. It's a reimbursement program. If you're in a program like group retrospective rating, several of your members are, it's not compatible with our drug-free policy, our drug-free program, but you can take advantage of this with group retro. Substance use recovery and workplace safety program is a program that provides the reimbursement for written policy development relating to substance use issues. It's critical that the employer have a strong, well-written policy to address all elements of the program. Any employment attorney is going to tell you want to make sure you have good, strong, well-written programs. We will reimburse for legal review of your drug-free policy. So with the way laws have rapidly changed, this is a great time to either develop a policy if you don't have one, or to review your current policy. Reimbursement for employee training and supervisor training includes a reimbursement for a train-the-trainer course. Employee education is going to focus on educating your employees on your drug-free program and the effects of substance use in the workplace. Supervisors, they need to be equipped to manage an employer's drug-free workplace program. They also need to know how to document reasonable suspicion and how to refer employees to available resources. So BWC will reimburse for drug testing, pre-employment, post-accident, random, reasonable suspicion, and return to duty testing up to $1,500 to employers if the employer has a written second chance drug testing policy. For a limited time, employers can request reimbursement for any of these components that you may have implemented going all the way back to July 2019. That's why it's very timely that I'm talking to you today. So once again, the majority of you, most of you, if you have a drug-free program, you've already implemented several, if not all of these components. Until June 30th of this year, if you've already implemented these programs, we will reimburse you going back to July 2019. Okay, 2 full years. As I said, yeah, July 2019. But that's only till June 30th of this year, because after June 30th, you can only request reimbursement for going back 1 year. It's very simple to apply. You can apply online and receive immediate determination of your eligibility. And the requirements to be eligible are fairly limited. To be eligible, the employer must be a state fund employer in good standing. And good standing means you're not more than 45 days past due on any balance, or you're current on an approved payment plan. You have to be in active or reinstated status. You have to have reported and paid your true up in the preceding year. So there are types of employers that aren't eligible: state agencies, self-insuring employers, and clients of PEOs or AEOs. PEO is a professional employee organization. AEO is an alternative employee organization that's relatively new. But if you're part of one of those, you'll know you wouldn't be eligible for the program. This program started as a trial in 2 Southwest and 1 Southeast Ohio County. But as of December this past year, it's available in all 88 counties. We partner with Adam H boards and several. Adam H board is Alcohol, Drug, Mental Health Board. And depending on the county you live in, and I can provide the information. If you're in a county where we partner with the Adam H board, your reimbursement would come from them. If you're not, and you're in a county where we don't partner with an Adam H board, then the reimbursement would come directly from us. So if you're a state fund employee, your policy is in good standing, you should be eligible for the program. I will make sure that Nancy has the information for the program, the link to our website. If you just go to our website and you can click on substance use recovery program, and page will come up with all the links, but I'll make sure that we have that information available to you. Thank you very much for your time. I just want to take a few minutes because the limited window to get that extra reimbursement.
Thank you, Tim. Yeah, I put the link in the chat. So
Perfect. Thank you.
absolutely, if you have a drug-free program and you want to get reimbursement for those costs, check that out. Thank you.
All right. Thanks again.
Thanks, Jim and Tim. Thank you, everyone, for calling in today. Like I said at the beginning of our meeting, we are working on some behind the scenes, trying to do an in-person, but don't be alarmed if you don't want to be in person. That's why we're trying to work behind the scenes. We're trying to do a hybrid type meeting to where we can still do a Zoom meeting for those who still feel comfortable being at home or in their office and still do something in person. So be on the lookout for that as we tried to transition to that at some point in the future. It's not next month, so don't freak out. It'll be more in a June range than June, July range, if anything. So also be on the lookout for the survey that will be sent out by Nancy. So please fill those out. We try to come up with topics that is interesting for everyone. I know it is difficult to grab the attention of everyone. Some topics are not as important, or as, I don't want to say important, that's bad, not as interesting as others. So but please fill those surveys out. We try to use those to plan our meetings in the future. So be on the lookout for that, and also for a Speedway gift card that is drawn randomly at the end of the meeting as well. So with that said, everyone enjoy this roller coaster of weather, and we will see and talk to everyone in April. Have a great day.